decision denying a request for a verification of non-conforming use to allow placement of a manufactured dwelling for student housing as Phase 3 of a 2004 land use decision, PA 509-PA 04-06222, approving a school building and 2 dormitories in an exclusive farm use E25 zone pursuant to Lane Code 162511. Property map and tax lot is 180225-00304, file 509 PA 1405775, owner McDougall Foundation, applicant appellant Laurelwood Academy, and appellant's representative, land planning consultants, and Bill Close. And this is a public hearing on the record, and the hearing is confined to the record of the hearings official for the file 509 PA 1405775. Argument is limited to issues already raised in the appeal and evidence in the record. Therefore, no new evidence is to be introduced today. Participation is limited to the persons identified in Board Order 1509-2909, the appellants and applicant owner and their representative, the planning directors, parties that appeared before the hearings official under Overholes and Luba case 2011-051. So with that, I'm going to first call for disclosure of board members of ex parte contacts. And if there's, obviously there's no absenteeism, but ex parte contacts. None. None? None on my part either. So, no ex parte contacts. And with that, what I'll do is have the planning director's report. I think Deanna's going to give that for us. Excuse me.
If I might, Chair, I think it's appropriate to call for not just ex parte contacts, but any bias or self-interest in the result.
And any conflict of interest. Sorry, I should have included that. Is there, in addition to ex parte contacts, does anybody have a conflict of interest in this matter?
None. No.
None. Commissioner Sorensen?
I have none.
Okay. None on my part either. Thank you. Thank you for catching that before I moved on. So, Ms. Wright.
Good afternoon, Commissioners. The item before you today is an appeal of a hearings official decision denying a request for a verification of a non-conforming use. The planning director approved the permit request, but the hearings official reversed the planning director's approval. So for some background on the item, the applicant appellant is Laurelwood Academy. The subject property is identified as tax lot 304 of map 180225. The 20-acre property is located approximately 1 mile southeast of the rural community of Jasper and approximately 2.6 miles from the Springfield urban growth boundary. The property is zoned exclusive farm use and is owned by the McDougall Foundation. On May 23, 2005, the applicant obtained final approval for a special use permit for a 3-phase construction of a school that included two 20-room dormitories and a classroom and administrative building. During May of 2013, the agent requested to complete Phase 3 of a school via a building permit. Land Management Division was not able to issue a final phase of the building permit because LMD believed the previous 2004 special use permit had expired and that state law and local codes had changed for schools in the exclusive farm use zone, making the use a non-conforming use. As such, the current application, PA 14-05775, was submitted as a request for a vested rights determination to complete Phase 3 of a multi-phased school project. The planning director subsequently modified the request to be an application for the verification of a non-conforming use and determined the applicant had the right to complete the multi-phase construction and approved the application request on May 15, 2015. On May 27, 2015, the decision was appealed to the Lane County hearings official by Landwatch Lane County. Most of the testimony at the hearings official public hearing on June 18th focused on how vested rights law instead of non-conforming use law was applicable to this request. On August 6th, 2015, the hearings official issued a denial of the request, and the applicant appealed the decision on August 18th. On August 21st, the hearings official chose not to reconsider and affirmed the decision. On September 29th, the board held a meeting as to whether or not to hear the appeal in an on-the-record public hearing. The board agreed the appeal met the criteria to hear the appeal and voted 4-1 to hear the appeal. So the appeal is centering on two issues. One, whether or not the original 2004 special use permit is expired or not. And in the alternative, if it is ruled that the original SUP is expired, then did the applicant submit enough evidence to establish that it has a vested rights to complete the project approved in the 2004 permit? As to the issue of is it expired, the hearings official believes the original 2004 SUP is expired. However, the current planning director and the appellant believe the original SUP is not expired. Landwatch Lane County, in their supplemental email, believes the 2004 special use permit is expired. The hearings official concluded that because the permit was not extended under OAR 660-033-140 subsection 2 to preserve the rights to complete the school project, that it expired. Excuse me. The applicant's attorney argues that under OAR statute, the text does not speak to completing the project, but rather uses the text initiated within the 2-year life of the project instead. The applicant did apply for a building permit for a school under BP 06-0038 on January 10th, 2006, within the 2-year final approval date of May 23rd for Phase 1 of the development. As a matter of past practice, LMD would consider a planning permit to be substantially implemented when the owner obtains a building permit and acts on the building permit by obtaining at least one inspection approval on an example where the request was for a single-family dwelling. Phase developments such as this one are not generally requested, so the history and past practice is uncertain. Here, the question is whether the project as a whole has been substantially implemented. The hearings official, as the appellant stated, flunked the application on the vested rights case. The HO points out that there was not enough evidence in the record to show a vested rights status, but that with greater details in the allocation of expenditures, a case could be made. But he goes on to state, even if a vested rights has been achieved, it was lost in regard to Phase 3, where no building permits have been approved and the project ceased for over a year. For the vested rights, the hearings official rested his belief on the project, that the project consisted of phased components, and that each of the phased components must be analyzed separately per his understanding of the case law listed in the memo. The applicant appellant disagrees and believes the 2004 special use permit was a single project, but with 3 different structures. If it is determined that the 2004 SUP is expired, then the appellant requests the board determine that the approval was granted for a school that contains 3 structures, a school and 2 dormitories, using the vested rights alternative. The 5 factors listed in the cover memo are what must be considered under the vested rights case law. The appellant believes that the expenditures are way above the proportion needed to achieve a vested rights, as summarized in their supplemental memo. Landwatch Lane County, in their supplemental email, believes the vested rights was lost because construction ceased for more than a year. In conclusion, the planning director recommends option 3 to reverse the hearing's official decision and approve the verification of non-conforming use. That concludes my staff report, but I'm able to answer any questions during the hearing if they arise.
Questions for staff? If not, then we will move on to the public hearing, and I will open the public hearing. And each party will be allowed 10 minutes, and then the appellant will have rebuttal time reserved. And again, I'm going to ask just the parties that were involved in the actual on-the-record hearing be allowed. So the first is the applicant appellant, And it looks like I've got Mike Evans signed up, or is that you, Bill?
Both of us, please.
Okay. So speaking for the applicant appellant, Mike, and
So for clarification, do Bill and I have to split the 10 minutes?
I'll look toward his legal counsel. Normally, I think it's 10 minutes reserved for the applicant appellant, and I don't know if that changes being a team or not.
I don't think it does, no, as far as my understanding of the code.
So I think you guys need to divide your time wisely for the moment. You will have opportunity for rebuttal, though.
Okay, well, I'll be brief then. Mr. Chair, Commissioners, my name is Mike Evans. I'm a planning consultant with Land Planning Consultants. My address is 475 Oakdale Avenue in Springfield, Oregon. Give a little history on this permit. The permit was for a school in 3 phases, and by phases it meant that all 3 structures weren't going to be built at once, but one at a time over a period of time. And so that was the first dormitory was built, and that initiated the land use special use permit. I don't think there's any disagreement between either the hearings official, ourselves, or the applicant that the special use permit was, at least on the part of or to the extent that the dorm was built, by the construction of the dorm. I think the breakdown in the disagreement where the hearings official found that it wasn't approvable was that he determined that the dormitory itself was a standalone school, and that the other components then required a continuation of the permit by repeated extensions. And I guess our argument is it's not. The school is a school. It has 3 components. It's a religious school. It's K through 12. Primarily it's high school students. It was to include a dormitory for girls, a dormitory for boys, and then a classroom. The basic fundamental components of a school. We acknowledge any other expansion if there was a gymnasium or additional classrooms or that sort of thing, then that would be an expansion of what was originally approved. We think the original approval was one use. That's where we get into the Hood River issue, where in that case, Bill will explain a little bit, was found to be a standalone Walmart building, store. This is a school and should include all components. I'm having to hurry here. I think it's critical. The staff laid it out quite well, but the staff itself considered it as being one use because it not only approved the dormitory, but which by itself, the approval process took about 8 months to get the design put together, turned into the county, and then it took 13 months to have the permit issued. Even considering that you have 2 years plus a 1-year extension, no larger projects like this could invest in any kind of development like this, because after 3 years, if the codes changed, the rules changed, which they did in this case, not in that exact time frame, then you can't continue it. So people who apply for this under the terms that the hearings official found could only plan for sure on a 2-year period within which they could obtain a permit to build all components. That same situation applies to dwellings, that there's a time period within which you have to implement your permit and that has been by the establishment of or obtaining a building permit for the structure. Once the permit was issued, a person starts construction. They can continue construction over several years, 4, 5, 6 years sometimes in building a house. They're allowed to continue, and that's based on that original foundation that existed for at least 40 years, where the county has determined that your permit is initiated with a building permit. Once that's issued, then you're allowed to continue. You're out of the special use permit period. I think it's very important, not for developments, not only for this developments like this, but also single-family dwellings. The initiation of the building permit issuance of the building permit is initiated of the permit. Land use is completed. You go on to the building permit. I think the important, or another important element is that through this process, the dormitory was constructed well after 2 years, the 2-year approval period, the county issued a permit for classrooms. That was 16 months after the approval had supposedly expired. After that, they issued a Lux permit. That was 18 months after the permit, the 2-year time period had expired. They issued another Lux permit, both these for sanitation. That was issued 4 years and 3 months after the initial 2-year time period, when Lane County took the position that this is an approved use and additional sanitation work and the classrooms can continue. Beyond that, there was a floodplain and driveway permits, both issued in 2013. So suddenly, we can't continue with the third component of this development that actually makes the school whole as was initially approved. Under this decision, I think the only thing that the county the board has to determine is, like I said, I don't think there's any discussion over the initiation, argument over initiation. It's that this development was the use of a school in its entirety. What we had proposed, the 3 different components of a school, that was what was approved, that's what was initiated, and is entitled to begin either under non-conforming use, or if we went into the vested rights theory, that same argument would have to apply there. I'll stop there and let Bill take over. Thank you.
I might be wise to wait for rebuttal.
Okay, because you still got 4 minutes and 35 seconds.
Well,
I did pretty good.
you did pretty well. I'm sorry. 4 minutes. I'll start talking then. Bill Close on behalf of the appellant. In searching for a way to organize this presentation, I did a lot of flopping around, and then I went to my actual appeal statement. I got to the last page of my appeal statement, and I listed 4 things that I wanted from you. And I thought, that's a good list. So I'm going to start with where I ended, which is asking for those 4 things. Number 1, in 2005, the county approved a single school to be developed in 3 phases. The school use is unitary when considering vested rights. Mike talked about this. This is not like a Walmart where phase 1 is 100,000 square feet and phase 2 is 30,000 square feet. Every square foot is the same. So you can see, you can lose that second 30 chunk of space if you don't get on it. But here, it's really a single use. I can't make that point much better than Mike did. The hearings official faulted us for not being able to shred out our expenses very well between the 3 phases. Well, of course, it's a single school. Every dollar you spend on a main or a drain or a gas line or something like that, it's going to work for all 3 phases. So, of course, we had a hard time shredding out the dollars. That's point number 1. Number 2, we'd ask you to conclude that the 2005 special use approval did not expire because development was initiated during the 2-year term of the approval. The school use did not need to be completed, or the 2005 permit extended to keep the approval active. This is the crankshaft of our gripe with the hearings official. The rule that he applied says, and I'm just pulling phrases from the actual rule, a discretionary decision, and that's the permit we're talking about here, a discretionary decision is void 2 years from the date of the final decision if the development action is not initiated in that period. It doesn't say initiated and completed. It says initiated. The record is very clear that during that 2-year period, we applied for the building permit and we started moving dirt. I think the staff report emphasizes applying for the building permit, but actual development was initiated. The record's quite clear on that. So somehow the hearings official decided you have to initiate development and you have to complete it during the 2 years, or you have to apply for an extension. And that, based on the language that I just read you, is not what the standard says. I've quoted that little administrative rule that gets dovetailed into the county code on the first page of my 2-page letter that staff gave you yesterday. So that's the most critical point. The third thing we're asking from you is there's a lot of discussion of this case with the funny name, Heidricken. I've read that several times. I reread it at lunch again today. It's not the same. The fundamental difference is, in that case, development never started. They never moved any dirt. They spent a lot of money on attorneys and engineers and planners and so on, but they never started development. We're completely different from that case. Third thing we asked from you, or asking you to include, is that as the hearings official found, looking at the school as a single use, the ratio of expenditures to total project costs supports a finding of a vested right to complete the school project consistent with the 2005 approval. If you consider this a single use, a school, and you look at all of the expenditures towards that single use, we are way over the percentage of expenditures needed to get that vested right determination. The hearings official had a hard time with our vested rights theory in terms of expenditures, only because he treated it like 3 separate projects instead of 1 project. So first phase is done, then he looked at phases 2 and 3, and he said, well, looking at those phases separately, you didn't spend enough money on those to get a vested right. But if you look at think of it as a single project, you look at all the expenditures, we're way over the bar in terms of what we need. That's point 3. Point 4, the right to complete phases 2 and 3 of the approved use was not lost due to any interruption of the use for a 1-year period. It's the use of the school that's relevant, not the construction, based on the definitions in your code. Here, this is an odd little wrinkle in this. It hasn't gotten much attention, but the hearings official said there's no argument that the school has continued through this whole period. But what the hearings official said is during this period, you took a 1-year break in construction, and so you've lost
You're at your 10 minutes,
rights.
Bill.
And it's about use, it's not about construction. Thank you.
Thank you. So with that, we'll have parties in opposition to the application, and I believe we've got Sean Malone. And you'll have 10 minutes also, Sean, after you state your name and all for the record.
Sean Malone on behalf of Landwatch Lane County. I don't think I'll be using my entire 10 minutes unless there's questions from the board, which I'm happy to take. There's really just basically 2 issues here, the extension issue and, as I see it, the non-conforming use issue, that is, the vested right was lost through discontinuance issue. I think they're both pretty straightforward. The first one I'll address is the extension issue. Now, just a simple reading of the hearings official's opinion states that for planning action 04-6222, which I believe is the original approval for this whole series of events that we're talking about, condition number 1 required a timely request to extend the permit to complete subsequent phases 2 and 3. And I can read that condition of approval number 1 for you. Approval of PA 04-6222 is valid for 2 years from the date of the final approval. Lane County may grant 1 extension of up to 12 months if, and it lists 4 possibilities. An applicant makes a written request for an extension of the development approval period. The request is submitted to the county prior to the expiration of the development approval period. The applicant states reasons that prevented the applicant from beginning or continuing development within the approval period. And then D, the county determined that the applicant was unable to begin or continue development during the approval period for reasons that the applicant was not responsible. So that's just a straightforward condition of approval that was in this initial approval, and there was no objection to that condition of approval in any way. The plain language of that condition of approval was violated because no extension was sought within those 2 years. That's how we're getting to where we are now. The simple fact is the applicant didn't abide by that condition of approval, and now the result is the applicant has to go back, resubmit the application, and now comply with all the new changes in law. Those changes in law that occurred are give rise to this whole vested right, non-conforming use issue, which I can go to unless there's any questions about that, about the extension issue. It's very straightforward. It's a violation of a condition of approval. It's very straightforward. The next issue here is kind of split into 2 here, vested rights on one hand, non-conforming use on the other hand. The most recent case from the Court of Appeals in Luba on this issue is my case out of Hood River. It has to do with this Walmart. That's why I think people are talking about a Walmart. Vested rights, non-conforming use are essentially intertwined. I look at this as not really an issue of vested right, because even if I can see that they acquired a vested right, that vested right was lost from 12 months or more than 12 months of discontinuance. That is, they stopped doing construction for in excess of 12 months. Under the county's code, that means they've lost their vested right, their non-conforming use. It's very clear in the case law. If we look at this, the case was Walmart v. City of Hood River. There are a couple cases that are in that line of case law because it was remanded several times. Another case is Crosley from the Court of Appeals. These are all in my written submissions below. And then Fountain Village. So there's 3 big cases from the Court of Appeals on this, and they are all very clear that it's not use, it's construction. You have to continue construction. If you discontinue construction for in excess of 12 months, you'll lose your vested right. The same time period was in Hood River as was here. It's 12 months. There's just the case is very clear that it's construction, not use. Actually, in the Walmart case, Walmart kept saying that we kept using these portions that we were going to use for our expanded area. We've used them for the last 20 years. Again, LUBA as well as the Court of Appeals found the other way on that. Same thing in Crosley and Fountain Village. It's construction, discontinuance. So really, when it comes down to it, vested rights doesn't, if I can see that they have a vested right to their development, they've already lost that. So it really doesn't matter to get into the vested rights issue. And then this issue of whether it's a phased development or a segmented development, I think the reason why that's coming about is that if you look at the vested rights as a whole, there's an argument, at least that the applicant's making, that the entire thing would be vested if it were looked at as one single unit. The Court of Appeals doesn't agree with that. They look at phased development as phased development, segmented pieces for determining a vested right. I know this because one of my other cases, Friends of Polk County versus Polk County, I believe, dealt with that issue, and that went to the Court of Appeals. It was a Measure 49 case. If you look at this again is cited in my submissions to the hearings official. In one of the previous iterations of the Walmart case, because that went through 3 remands, LUBA addressed that case and stated, sort of reiterated what the Court of Appeals determined in that case. And I can read that for you real quick here. That's in my June 25th, 2015 submission. On page 2, we're quoting from Hood River Citizens for Local Economy case, which is one of the cases in that Walmart line of cases that were on remand. Addressing this, it was Friends of Polk County v. Oliver was the case. And in that case, an applicant sought a vested right for a phased development, a large development, and this is LUBA, what I'm about to read, summarizing that case. The court seemed to analyze different phases separately, at least for purposes of the expender ratio test in homes. That suggests perhaps that different phases where components of multi-phase or multi-component project are analyzed separately. If so, the failure to obtain a building permit for the expansion of the work and commence substantial construction may mean that no right to complete the expansion ever vested. So again, they're looking at, Court of Appeals was very clear, they're looking at each phase individually. This was clearly a phase development. But again, all of this doesn't even matter because assuming they had a vested right, it was lost through discontinuance. And that implicates construction, not simply use. Crosley, Fountain Village, and the Walmart case bear that out specifically. If there are any questions, I'd be happy to take them.
Commissioner Sorensen?
I would like to know, given your view that the hearings official decided the case correctly, how do you respond to the argument that each phase should be taken on its own, and that the phase itself is is implied that the county had approved it, and therefore they had that vested right. Do you take the view that that vested right, whether it exists or not, is expired because they didn't begin the construction?
Correct, 100%. That's why I really don't spend much time on the vested rights issue here, because it's, you got to weigh a bunch of factors. I did a lot of this through Measure 49 litigation when I first started doing this stuff. You have a ratio test, you have sort of good faith, you have all these things, and they're pretty loose, and a lot of interpretation going on there. And so you can spend a whole lot of time on that, but why do that if the outcome is that they lost that vested right through discontinuance? That is, they stopped construction in excess of 12 months. That's according to the very plain language of the county's code. And so an alternative way to get around that, I don't think could ever be upheld at LUBA. So yes, the vested rights issue is one that it's involved here, but it really doesn't even have to be gotten into, because that vested right was lost through discontinuance.
Okay.
Commissioner Lycan?
Thank you, Mr. Chair. So the examples you used, Walmart, obviously, I know what Walmart is. Fountain Village, what, is this a housing complex? What is that?
Crosley and Fountain Village were, I believe they were just individual residences, having to do with, that's why the Walmart case, in each of those cases, let's put it this way, the applicant, Walmart, the individual in Crosley, and the individual in Fountain Village all started construction on some. For the other two, it was homes. Walmart obviously was a Walmart, and they just never finished that construction. Walmart, they didn't finish it over 20 years. In Fountain Village and Crosley, the individuals, I believe, was on their homes, didn't finish construction for a couple years as well. But in each of those, I believe the relevant standard was in excess of 12 months. It's very typical for discontinuance of a non-conforming use. It really just comes down to whether you're going to have you discontinued construction to complete your project. It would be incongruous for an applicant to sit on his ability to.
Sorry, that was 10 minutes, but we were answering a question.
Oh, yeah.
So.
It would be incongruous with the law to allow an applicant to sit on his vested rights for 10 years, 20 years. The county's decided 12 months is the limit there. So with that, I don't want to take up any further time, unless there's questions.
Could I have a follow-up on that, Mr. Chair? Would you like to wait until after the rebuttal?
Let's wait till after rebuttal.
Okay, I'll save it.
Okay, thank you.
Thank you.
And I'm not sure if those are questions you want to ask our counsel or.
So I think I would.
Yeah. But we can.
Yeah, and I'll wait, Mr. Chair, until you're finished through the process.
Thanks. So we'll move on to rebuttal by the applicant.
Thank you, Commissioners. I have 4 points to make in rebuttal. Maybe 5. My 5th point would be my first point. I think Sean Malone and I would be in complete agreement that this little body of law is really kind of a mess. It's a sticky area, non-conforming use, vested rights, and such. In his remarks, Sean Malone focused on Condition 1 of the 2005 approval. And he said that condition required, regardless, I guess what he says, regardless of what the state law on duration of permits might say, that condition says if you don't, you need to get an extension at the end of a year. But that's not what it says. The Condition 1 on the approval has 4 subparts, and it starts out by saying, approval of PA blah blah is valid for 2 years from the date of final approval. Lane County may grant one extension of up to 12 months if, and it lists 4 subparts, and one of those subparts talks about the applicant beginning construction. I guess, so the language of the, I guess what I'd do is I'd go back to the state law on this, and the state law, the county code has to be consistent with state law because this project is taking place on EFU land. And whenever you have approvals on EFU land, state law applies directly. So the law that governs this is the law that I read in my opening remarks, which says your permit is void unless you initiate development in 2 years. And that happened here. So you then jump to the conclusion, because development was initiated, that land use approval did not expire. And that's where we think the hearings official goofed. So keep in mind that because this is all happening on EFU land, the state law applies directly. The situation is really different if you're on, like, exception land, if you're talking about rural industrial land, or rural commercial land, or rural residential land, where you don't have the state law cutting through and applying directly. So that's the first point. The second point relates to vested rights in these other cases. The world of vested rights law is divided into two categories. You got your cities and you got your counties. For counties, the structure, the skeleton of vested rights law is spelled out in some detail in state statutes, RS 215-130 and subparts. And counties can play around a little bit at the edges, but the bones of it is common from one county to another. And that's what we're dealing with here. So then you move to the Hood River, Walmart versus Hood River case. And what do you see? It's a city. And in cities, state law does not, the state statutes relating to vested rights don't apply at all. When you get into a city, better for worse, cities are 100% in charge of drafting their own law relating to vested rights. I mean, there's the equitable business, the ultimate equitable test that comes with Holmes versus with Clackamas County. But cities are allowed to write whatever they want in the way of vested rights law. And so when you see a vested rights case that says Walmart versus Hood River, you say, not applicable, because they're not applying the same statute that the county's applying here. So that's a fundamental difference between, when anybody talks about vested rights law, ask yourself, is it a city or is it a county? And if you're sitting in a Lane County seat, you really shouldn't be listening to any vested rights law from a city. The third point I want to make is about deference. We've really asked you to make a couple of factual determinations here. Now remember that when this gets up to appeal at LUBA, you can always smell these things when they're headed towards LUBA. When this gets to LUBA is bound by state law to defer to any factual findings that this board makes. It's the only area they defer the counties on. And so we've asked you to describe this school as a single project in 3 phases. If you agree with that and you make that finding, we're way ahead of the ball game when Landwatch takes us to LUBA. Because LUBA will defer to that finding. And the second relates to the issue of discontinuance of the actual construction for more than a year. That happened courtesy of the Great Recession. Everything stopped for more than a year. But the school use itself never stopped. And, your code defines the word use. And as we told the hearings official, when the statute says discontinuance of the use for more than a year, you go to the county code to find out what a use is. And use under the county code means the use of the school, which is different from the construction of more parts of the school. That's a critical finding of fact for you to make. And if you conclude that the use, for purposes of discontinuance here, is the school use and not the construction of the next increment of the school, we'll be in much better shape when we go to LUBA. So that's point 3. Point 4 is kind of an editorial. It's hard to understand why Landwatch takes on issues like this. It's true. The property we're talking about here is zoned EFU. But this school also sits on a 2-acre slab of concrete. It's part of an old mill site that was shrunk across the street to the north side. And on the south side, on the 2 acres of concrete, the school is being developed. Well, it's zoned EFU, so we get the baggage of all the state law that applies to protect EFU land. Is it EFU land? Of course it's not EFU land. It's a slab of concrete. If this property were zoned rural residential, or rural industrial, or rural commercial, we wouldn't have this problem, because this new and improved law that LCDC passed in 2010, 2009, whenever it was, wouldn't apply to us, because that new rule that limits schools within 3 miles of an urban growth boundary applies on resource land, farm and forest land, not on rural industrial, not in rural commercial, not in rural residential. So if all goes to the winds and we get, you decide what you're going to decide, and we go to live and we lose, the owner, if they want to keep this school going, can come back and ask for a plan amendment to make this property rural industrial or rural commercial on a committed lands theory, because it's committed. It's committed because it's concrete. It can't be used for resource use anymore. And once we are planned and zoned what we really ought to be planned and zoned, then this rule doesn't apply, and we can finish the school without all this litigation. But that's the long way around the block. That's the long, slow, expensive way around the block. The short way around the block is finishing the process we have right here and getting a favorable decision from you folks. Any questions?
Thank you. So with that, I'm going to close the hearing, and we'll turn to discussion and action by the board. So I'm going to close the hearing. And questions, Commissioner Lyken, I think you had some questions for our staff.
I did. Thank you, Mr. Chair. So I think a lot of this, the conversation, and what I've heard from both sides, we're kind of focusing around the vested rights law, and frankly, when you read what the hearings official stated, his first sentence, it is with an excessive caution and recognition that the law in this area is less than clear. And I think that's probably where that jumped out at me as much as anything. So I've heard from both Sean and Bill, and I appreciate both of their thoughts and their expertise from where they're coming from. The other piece is this, and Andy, I guess this is where this is where I'm trying to figure this out as we go forward. One way or another, I think something's got to be codified here, because you're looking at the Walmart piece, you're looking at the other that Sean was explaining that sounds like a residential. Is that just a nod? Okay. Here we're looking at a private school and owned by a foundation. And a lot of times those schools are built out in phases where, I'm sorry, my family's in residential construction for 40 years. So, I don't know, the last I checked, when we wanted to do a development, we actually wanted to put forth a development and actually hopefully reap some sort of benefit. Well, also where folks who are buying the homes would also have benefits as well. But on this is where you're looking at a school. A lot of times they are building out in phases. And so this is where I think the last time we talked, we were having this conversation about vested rights. Frankly, I think he muddied this up a little bit in the way he came back and basically denied the county's approval. So, from a legal standpoint, Andy, I don't know. This is probably where I'm having issues on as much as anything. So you heard from both Sean and Bill. Bill focuses more from urban compared to the EFU. I guess I'm going to say to you, what say you on this piece? And was Kent correct on the moving forward on this approval, or is Mr. Darnell correct on saying, no, I'm sorry, we need to deny this? I understand his whole denial. It's not all on vested rights, but frankly, that's probably where I'm going to be hung up on as much as anything. So I guess I'm trying to get from you where this should be falling as far as the county is concerned, because we've heard now from the folks who represent the schools. We've heard from those who want to that appeal this. But I'm asking from the county's perspective, what say you?
Well, I probably can't give you a very good opinion on what I think the law is on the vested rights piece, because then I think the hearings officer's official is correct that it's a fairly muddied area of the law, especially when it comes to phased developments. And I did not go through all of the case law on specifically how vested rights are treated in phased development projects. It's conceivable you could legislate in that area. Obviously, it doesn't affect this case. To try to pin that down some more, I guess looking at it from my standpoint, I found the vested rights analysis to be the less significant, frankly, than the analysis of whether or not this permit has expired, and if so, with respect to what the whole project, phases 2 and 3, that scenario. I will say from a legal standpoint, I disagree with Landwatch's analysis of what this permit says. I don't think it's easy to look at the conditions of approval that folks are referring to and say clearly that expired because construction wasn't complete in 2 years. It doesn't say that. That's not what the permit says. The permit is a little, and when I say that, I mean the conditions of approval that go with the permit. They're a little bit ambiguous because they say the conditional use permit is valid for 2 years. Until when? It doesn't answer, to what do we have to do within 2 years to be complete? Unlike the rule that Mr. Close referred to, it does say essentially 2 years to initiate. I think our condition of approval gets there when it talks about the extension. If you want to extend it for 12 months, you need to show A, B, and C. And one of the things you need to show is that the applicant would need to show there are reasons that prevented the applicant from beginning or continuing development. And to me, if part of the justification for an extension is we need to show why we haven't begun yet, I think that gets at initiation. And I think that's why I disagree with Landwatch's interpretation of what that condition of the permit says. That doesn't answer the question entirely for me, and unfortunately it's kind of where the board has to come down is if you have to initiate within 2 years, and clearly there seemed to be evidence in the record indicating that some of this project was initiated within 2 years, is that enough? Does that cover the entire project or just phase 1, which basically was complete, I think. Phase 2, it looks like they obtained a building permit in 2008. And it may be phase 3 where there wasn't a building permit obtained. So that's the factual issue here, is whether we just look at the entire project as a whole or whether you divide it up. And the hearings official's decision isn't convincing on that point for me. I don't think he discusses it in any great detail. That unfortunately talks about the permit. Your question had to do with vested rights. It's a difficult area to analyze, but you get down to the same issue, I think, is the phase development separate and discrete, or do we consider it all one? The applicant faults the hearings official because he was very distinct in separating those out and dealing with what costs are attributable to what phase. Applicant makes the point that it's pretty hard to distinguish what costs go to what phase, and therefore, there's not enough for phases 2 and 3. If you're dealing with it as an applicant, as a developer from one big project, you wouldn't dissociate those costs, I suppose. So those are my thoughts on the issue. If that helps.
No, I appreciate that. Frankly, I think both attorneys made very compelling arguments, and they're both very good at what they do, and I appreciate that. The last thing I'll say is this: I don't think we can consider the Great Recession into this whatsoever. What I found is that when you're a builder, you take risks, and you reap rewards prior to that. And unfortunately, I knew some general contractors or some builders who had some challenges. Next thing you know, they were teaching how to build a deck at the Home Depot. I mean, that's life. And I don't think you can I just don't think you can bring that into what we're discussing. While from a personal standpoint, I would absolutely say that yes, there was issues there, but from what we're trying to decipher here, unfortunately, that's something I don't think we can bring into the argument. But I appreciate your your assessment as well. And again, I think both Bill and Sean did a very good job in explaining their positions. Like I said, I think they're both quite good at what they do. So it's going to be a difficult decision no matter what. So appreciate it. Thank you.
So I'm going to slip into the queue real quick and ask a couple very simple questions. If the board made a factual determination that the conditional use permit issued back in 2005 under the 2004 planning action had actually been satisfied by the initiation, we determined initiation did happen, is there any further action needed by the board? Because basically that would mean that the permit's in place, or the ability to continue the project's in place. If we determine that conditional use permit was satisfied and the land use is still in place.
Yeah, I think if you decide that the permit has not expired, yeah, the applicant can continue on with the next portion of the project, whatever needs to be done.
And then discussion of vested use doesn't even come into being.
Correct. But I should point out that determination by the board wouldn't be a factual one necessarily. It is an interpretation of our code and the state rule to an extent as to whether the permit is expired. I mean, there are obviously facts apply, like what dates certain things were done, but it's not purely a factual.
I don't think any party has described the fact that there wasn't construction done within those 2 years. A permit pulled and construction begun within the 2 years.
Correct.
That's a factual statement. Yeah. So if we determine factually that was done, and then we determine that from our reading of law that is considered initiation, correct, we could consider the conditional use permit still in place.
Correct. Yes.
So I just want to make that clear. That's to me is the first step that we have to decide as we hear this case. If we determine that conditional use permit is not in place, then it becomes a question of vested rights and the muddy law that is vested rights at times. But I've got our definition of use up here, and I am certainly not seeing the word construction anywhere in the definition. And from what I understand, we have a case right now where we have actually cited somebody for losing their vested right on a project that had been constructed years ago as a non-conforming use out in some F1 land, and it was a discontinuation of the use that lost their vested right, not the fact that they didn't finish construction. Otherwise there would be no way to lose your vested right ever. Even if you abandon a property, say this Walmart in Hood River, they had decided to go bankrupt or whatever, left the building vacant for 2 or 3 years, and then somebody came back in and tried to come in under their conditional use permit and say, oh, well, we've got a right to go back to that same use. There'd be no a discontinuation of use for years. So I'm struggling with tying construction, completion of construction or discontinuation of construction, because I don't, the record's pretty clear that there has been continual use of the property as a school. There was no interruption, and I think the factual record shows that. So I'm kind of, for me, it's answering the question, did the continual use permit get satisfied? And is that land use approval still in place? Is the first question for me to answer. And as I'm looking at the record, I'm already kind of leaning that direction. And then if you get past that and you have to deal with vested right, I think it's a stretch to say discontinuation of a construction period for a year loses a vested right. And also then you get into whether you're talking about phase construction. As I look at the application and the approval doesn't mention a 3-phase approval. It talks about the approval of the school and 2 dormitory buildings as one project. It never splits the project up into phases in the approval process. It seems to deal with this is all one project. So as I look at the decisions before us, is first we have to determine whether the conditional use permit actually expired, and the fact that we were actually issuing land use compatibility statements and driveway and floodplain permits as recently as 2 years ago kind of says that we thought it was in place too. Even though there had been that year back in 2008 where they didn't do any construction work. So I'm kind of looking at the record and the factual record, I'm kind of thinking that the hearings official was trying to be super conservative, trying to split this thing up into phases, trying to find a reason why it didn't meet, didn't have its continuation of its land use, so now you're dealing with non-conforming use and vested rights. And I think it's a pretty tortured set of logic he got there from. And I have a tendency to try to agree with the appellant here that they never really lost their land use, and I think in that case, therefore, they've got the right to complete what they had the permits to do. Commissioner Sorensen?
Thank you. I just wanted to ask a question about something that was mentioned, I believe, by Mr. Close, and that is that the land is a former mill site, and it has a big pavement concrete slab, but it is a exclusive farm use, and he said the owners could apply to have the land rezoned so that it would not be exclusive farm use. What relevancy is that to this case? That the farmland is covered with the slab, and for practical purposes, it's not farmland, but it is zoned EFU.
I assume that question's for me, Commissioner. Is that right? I don't see it as relevant to the decision of A, whether the permit has expired, or B, whether there's any vested right if it did expire. So, yeah.
And if the board does decide opposite the hearing, or in favor of the hearing official's decision, and opposite the approval, then the opportunity to have the rezoning is still in place. In other words, to say, well, we were denied because it's EFU, but now we're petitioning to have the land itself rezoned because it's not, at least in the applicant's opinion, it's not EFU.
I think that's correct. If this board upholds the hearings official's denial here, the opportunity for the applicant is to go and try to obtain approval for the remainder of the school under the existing law, and I think most folks, the applicant particularly looking at, thinks that's probably not going to fly because of the rule change. And I would assume that their other alternative, as Mr. Close explained, would be attempt to rezone the property where the school exists, and his pitch there was it's probably committed to uses other than EFU uses, and so but I obviously can't speak to what their possibility of that sort of a rezone would be at this point.
Commissioner Stewart?
Thanks, Mr. Chair. I kind of follow on the same thought process as Commissioner Bozovich has said. To me, really, the first thing I have to settle in my mind is whether or not the permit's expired or not. And as I read the condition of the approval, it says the approval is valid for 2 years, and then you go down and it talks about reasons prior to, the applicant states reasons that prevented the applicant from beginning or continuing the development. It's clear to me that the development started, and there's no verbiage in here under the conditions of approval that it has to be completed within the 2-year period or within an extension. And if you go to the state law, it's the same exact thing. It has to be initiated. The project is clearly on the record. It's been initiated. So to me, I don't believe in my mind that the permit is expired. they're moving forward. I also look at the project as one project, one complete project. Just because you construction, you phase out going and getting your permits and designing and doing the work over a period of time. You've done that based on your resources and your ability to do the work. It's the same way I did a project in Cottage Grove. It took us 12 years to do the project, but you put infrastructure in one phase. It's still one park, but there's lots of pieces to the park that you're completing. So for me, I have to agree with the recommendation that I believe that the project and the permit's still valid, and that there's no reason for me to believe that they needed to complete this school with 3 buildings within the 2 years or file for extensions. Boy, if that's the case, there's going to be a lot of difficulty for people in any type of business that they're operating that has any magnitude in construction, as we learned this last week with permit processes and timelines and everything. I mean, if you got to spend 6 months in a permit approval or a year in a permit approval, you're going to violate your conditions of your land use. So I'm following the same thought process here as Commissioner Bozovich at this point.
Any further discussion by the board? Questions for staff or deliberations? Commissioner Farr.
I guess I don't know. I'll ask if this is a fair question. Mr. Close had an editorial comment about why would Landwatch even care about this. I think I'm paraphrasing that. Is that a fair question? Why would Landwatch even care about this if it's already been it's been a slab for how many years, and it's just some subsequent zoning that probably some inadvertent zoning for that matter that declared a slab as exclusive farm use.
Well, I think you're right. I think it's an editorial comment. Yeah. Clearly, it sounds like historically that the use of the property was one that was consistent with the zoning at the time, which is as a mill site, and that the actual mill operations have shrunken down, leaving this piece not part of that anymore. And it's, it's sort of a leftover vestige of that previous use.
Okay. So discard the editorial comment. I guess I'm listening to the discussion that's been taking place, and to me it hinges upon whether or not the permit had expired. And I've been a part of building big projects that take a lot of years to build, and it seems that unless there's something very specific about the expiration date on the permit, that it's an ongoing project that continues to be built. So I guess I'm following along with Commissioner Bozovich and Commissioner Stewart regarding the expiration of the permit.
So I have one question. The staff had recommended option 3, which was moving to reverse the hearings official's decision denying the request for verification of a non-conforming use. Is that even necessary if we've determined that the conditional use permit is actually still in place, or do we have, is that part of the verification of non-conforming use could be that the conditional use permit is still valid? I guess I'm kind of asking a question because I'm not quite sure. I want to make sure that as we move forward with a motion that it's directing staff to prepare the correct set of findings.
Procedurally, it's.
I mean, I'm kind of wondering why they're going through a non-conforming use.
I think
if
because
we determine that the conditional use permit still is in place, if we do that as a board. So that's kind of my question: is what action is the board taking today?
As I understand it,
if that's and that sounds like, from what I'm hearing, the direction we're going.
Yeah. As I understand historically, it came through as an application originally, Frank, for a non-conforming use, but as we've heard, non-conforming use and vested rights are sort of part and parcel the same thing. But I think it started with that application because at the suggestion of a planner in land management, with the idea that this permit is old, you should see if it's still good. If the planning director's recommendation now is essentially that it agrees with, at least I think, 4 members of the board now, that the permit didn't expire, and therefore there's no need for the approval of the vested rights piece of it. I think you can approve the application, but it wouldn't be as a vested right, because the vested right approval can have very specific limiters on exactly what rights have vested versus what haven't. If the decision of the board is that the permit is not expired, you can approve the remainder of the development under that permit. In other words, a yes vote on what's before you, but on specific grounds that actually don't include a yes on the vested right, if that's the decision of the board. You could also approve the vested right application, as well as alternatively approve the permit or the decision the permit hasn't expired. It can continue on that ground as well. So there are those 2 alternatives.
So the question I have then is, as I look to my usual motion maker, do you have enough information maybe to make a motion off of this? It sounds like we're leaning towards option 3. Is it just merely a motion to approve option 3, enough direction to staff, or do we need to add? So is a motion to approve option 3 enough direction for staff with the discussion that's going on, or do you need us to actually work into that motion that our reason for leaning that way is we feel the conditional use permit's still in place? I just want to make sure we make the correct motion for you guys. So when you come back with the board order and findings.
Well, I suppose a motion depends on what you want to approve. If the board wants to reverse the hearings official's decision regarding the vested rights, and therefore find that there are vested rights to continue, you can do that, and that's what option 3 essentially entails. If you want to do that and add to it that the permit is not expired, and to come back with a decision with findings to that effect, that will take a motion.
I think if we find that the permit hasn't expired, there is no discussion of vested rights.
And that's fine too. If you want to make the motion to be just on the permit itself, do that.
Okay, Mr. Chair, I would attempt a motion here. I'd like to move option 3, which is to reverse the hearings official's decision denying a request for verification of non-conforming use, and approve the request and direct staff to prepare an order with appropriate findings for the final action, with the inclusion that the board believes that the current permit has not expired.
Second.
It's been moved and seconded. Discussion to the motion? Seeing and hearing none, all those, is this a voice vote, or is this this is not an ordinance, so I guess it's just a voice vote. So all those in favor, please say aye. Aye. Any opposed?
No.
Motion passes 4-1 with Sorensen in opposition. So do you think you have clear direction, Deanna?
Yes.
Thank you. And I want to thank everybody for coming today, and that will conclude our discussion on this item. Now, if I can just find my agenda again in my seat.
We will put together an order with findings and come back to the board at the earliest convenience.
Thank you. And I think we're on to review of assignments.
Okay.
Mr. Chair, the only assignment I had is related to the discussion on 8B, the formation of the Fern Ridge Public Safety District. And obviously, the board's direction is for our staff to work with the residents, City of Veneta, and other officials to provide assistance, both staff assistance, coordination with assessment and taxation, and any legal counsel that's appropriate to provide support there. So we certainly will follow up on that effort. That's the only item that I had. Follow up unless I missed.
Does anyone have any other items? Thanks. Is there any other business for the board today? If not, we will adjourn and we'll be back in session tomorrow at 9 o'clock. Just a work session. Yep.